A very hearty good evening to all of you. Dear students, in the last class, we have seen the case laws, which was specifically dealing with dwelling houses, family shirings and idols, staircases, wells, etc. And also the subject matter of partition. We have discussed in length and the properties incapable of divisions, rules of partition of such property, which we have seen the properties which are capable of division and the properties which are capable of divisions. So these are the, you can say, a sort of a list which are incapable of division. The rest of the properties are deemed to be divided and they can be further divided because the rules and the laws are accepting the particular norms that there are certain things which are, we can say, incapable of being getting divided. Also, I would like to discuss with you as we have received we can say, a mail, the APC, Academic Planning Committee, from SBA, and SBA was talking about the length of the lecture, that the length of the lecture is quite long, and therefore they were willing that we should lessen the time of the lectures. So I need your, I can say, consensus regarding the same. What is your view? What is your opinion? Whether you are willing for a long lecture or you want something 35 to 40 minutes. So somehow I will try to make today's lecture not so lengthy as we used to have in our previous classes, long lectures. But it depends upon your opinion because your opinion is crucial for me because it is your opinion which I have to go through, I have to check because till date I haven't received any what I can say any request from your side to lessen the hours of the lecture. Okay, so in the last class we have discussed in detail the issues which I told you. So today I would like to start, although it is not deductions and provisions are not something which are there or discussed in your syllabus, but the role of a teacher is not only to cover the syllabus, but as to uncover it also. There are instances which are somewhere related with a topic which we are dealing. So whenever a partition happens, there are certain issues which has to be rectified, sought out, considered before the partition completes its role. So what we have seen that ordinarily when we talk about the joint family property existing at the date when severance of status occurs, so the relations are ending, the relation ends. So subject to what has been said under the preceding head are available for division. So however, before division can take place, the Shastrakars have ordained that out of the joint family property, provision should be made for certain liabilities also. So whenever there are assets which are coming in, those assets are also incurring or having certain liabilities. This is the, you can say, the rule of the business also. If you are purchasing a thing, you are purchasing the property, then all the incumbents which are upon the property has to be really met. And if there are certain issues or taxes or whatever, in transfer of property also the same rules apply. If there are certain debts on the property, certain liabilities on the property, then that also is passed. And the same thing applies here also. It is not so that a particular person has taken some loan or some debt on his particular property, and then what happened further when he is not able to pay, he is willing to transfer it to someone else. So no issue, we can transfer the property, but the question is that whatever is hanging on that particular property as liability, that also will get transferred. So here also there are certain things which has to be seen. If we talk about the very first thing is the debts, a provision for payment of outstanding debts binding on the joint family should be made. It is very crucial. Whenever we are talking about the joint tax, it has to be, we can say, it has to be made. So in the case of Satyanarayan versus Das, it has been observed that debts taken by the Karta for a purpose binding on the joint family Okay, so what are the debts? That particular debt has been defined in the case of Satyanarayan versus Das case in front of you in your screen, just adjacent to debts. In this particular case, it has been observed that that's taken by the Karta for a purpose, binding on the joint family, and B, untainted personal debts of the father in case joint family consists of father and sons. So two things have been discussed in this case. The very first thing is that debts taken by the Karta for the purpose binding on the joint family, that has to be deducted from the partition, that particular amount, because it is a liability and it has to be paid, okay, to the person from whom you have taken a debt. And second is untainted personal debt of the father in case joint family consists of father and sons. These are the things which have to be looked forward. And there is a rule that you have to remember that no provision is to be made in individual debts of the co-partners. If the debts of the co-partners are individual, they have taken the debt in their individual capacity. That particular debt hasn't, it is not to be met with the joint family property. Okay, now coming to the term of maintenance, when we say maintenance, so maintenance, there are certain members of the joint family who do not take a share on partition but have a right to be maintained out of the joint family funds. Okay, there are people who are not having any rights on the share, and what they are having a right. They're not having a share. They are having a right to get maintenance out of the joint family funds. Further, a provision is to be made for their maintenance. Such persons are, you can say, disqualified co-partners and immediate dependents. There is a list which we can see, which we can discuss. Okay, so in the case of Commissioner of Income Tax versus Bhagwati, such persons have been defined. In the case of Commissioner of Income Tax versus Bhagwati, and it says that a disqualified co-partners and their immediate dependents, such as wife, daughter, son, and in certain circumstances, illegitimate sons. So these are the people who have been made qualified to ask or to get the maintenance. So, okay, disqualified co-partners are there. We know that earlier the females never used to get the share as a co-partner. And this case of Commissioner of Income Tax is an old case. It is a case of 1947. It is not a new case. It is a quite old case. And before we can say the codification happened of the Hindu law. And therefore, in this case, they have tried to provide a list that told you that disqualified co-partners and their immediate dependents, such as wife, daughter, son, are in certain circumstances illegitimate sons. Okay. Then further, it has been defined in the same case. In the same case, it has been defined mother, stepmother, grandmother, and other females entitled to maintain it out of the family property. Okay, so these are the people who are so the mother, stepmother, grandmother, and other females are also entitled to get the maintenance because these are the rules which we are trying to appreciate, and these are the rules as the case law is of 1947. At that particular point of time, the codification was not there, and what we can say the Hindu Succession Act was not so has not evolved. Okay, so these were the things. Also, the unmarried sisters till they are married, widow daughters, and of deceased co-partners when they are entitled to be maintained out of the joint family assets. So these are the people we can say the people who are uh, falling or coming under the category of disqualified co-partners. Okay, so further we are having marriage. When we talk about the term marriage, marriage in itself is a term which we have discussed with different aspects and different dimensions. Now we are dealing the marriage with a perspective of partition. We have seen what is the duty of karta, legal necessity, and we have seen other aspects of marriage also, why marriage is so crucial, so important. Okay, what is the you can say the significance of marriage? So when the co-partners consist of father and sons, a provision should be made for the marriage expense of the daughters of the father. This is the rule, and this has been discussed in many cases. For example, Chandra versus Nanak, although I haven't mentioned it because unnecessary, it will make things more complicated for you or lengthen the thing for you, will make the thing longer because this is a part of a portion as I discussed you. Apparently, it is not there in your syllabus, but because it is somewhere related, that's why I'm trying to discuss it to you. If you are willing, you may note down the name. The name of the case is Chandra versus Nanak, and it was held that in this particular case that a provision should be made for the marriage of for the marriage expense of a daughter, okay, of the father. So also we can say that whenever a co-partnership consists of brothers, they should be made provision for the marriage of their unmarried sisters. For the unmarried sisters also there is a ruling of the court, and in the case of Rajgopala versus Venkatarman, Rajgopala versus Venkatarman, the same thing has been discussed. Also, the Smritikars and the commenters stipulated for a share to a daughter in such cases. Okay, and the Takshara school, Daya Bhaga school are having certain bent of mind regarding this particular, you can say, concept of marriage. Okay, but in the modern Hindu law, if you try to see, it has remained a provision for the marriage expense. And the modern Hindu law also tries to appreciate the expenses which are related with marriage, and those expenses which are related with marriage has to be set off before the partition is completed, before the partition is made, before the co-partner acquires their shares. So all the co-partners will be asked, and those who are directly liable for it. For example, if suppose a partition happened between a father and a son, father may ask for this particular thing to ask for the you can say the particular share. Okay, so in case of a co-partner dies before partition, leaving behind an unmarried daughter and no male issue, then a provision should also be made for her marriage. So in case a co-partner dies and what happened, leaving behind an unmarried daughter, so and no male issue, then a provision should also be made for a marriage. No provision has to be made for the marriage of unmarried co-partners. If there are unmarried co-partners, because co-partner, it is assumed that the co-partner are the people who would be getting directly. They are the one who would be getting their own share. So there are no, we can say, set-offs or some sort of provisions or rulings in case of the co-partners. But in the case of people who are support dependent, for them we are having certain we can say reservations. Okay, then we talk about in the case of Ramlinga versus Narayan. It was held that in this case no provision has to be made for marriage of the unmarried co-partners. Number one, we have seen, or for the daughters of other co-partners, because that particular co-partner would be getting his share, and therefore that particular co-partner should not be asked or should not be given the same thing. Okay. Since the marriage of such daughters is a responsibility of the respected fathers, this is also a reason that the responsibility of the daughters should be bear by the father, and the father has to look after the marriage expense and the responsibility of his daughter. Then when we talk about the performance of ceremonies, there are certain ceremonies which are having, we can say, the concept, it is something related, we can say, in line with legal necessity. So in legal necessity, what is going on? The Karta is having the power of alienation. There, Mr. Karta is going for asking for the money with certain necessities. That is, this provision is already there. But the circumstance is different. Now here the partition is happening. And before the partition, this particular subject is coming. So this particular subject can be classified or can be treated under the performance of ceremonies before partition. Are you able to get what I'm trying to tell? Okay, if suppose partition happens, if a partition takes place among brothers, a provision has to be made for the funeral expense of the mother. Now there is no karta. If suppose a partition happened between two brothers, and now at that particular point of time, what happened? Their mother expires. She dies. In this particular case, the partition, the provision has to be made before they take their shares. They have to met the funeral expense, whatever she's incurring. And the same thing was discussed in the case of Jairam versus Nathu. In this particular case of Jairam versus Nathu, it was held that provision is to be made for the performance of other essential ceremonies such as sacred thread ceremony and so on. So here also we can say it depends upon the court. The court is having the power to decide what are the terms which will fall under the categories of performance of ceremonies. Okay, so this was in short regarding the deductions and the provisions which I tried to bring in your what I can say to your knowledge, because these are the deductions which has to be made. If you read any law which is related with, we can say, the distribution or the segregation of property or money, whether it is transfer of property, whether it is income tax, whatever. Even in companies laws and partnership, there are certain provisions which have been expressed in those specific laws in relation with deductions and set-offs. Because if you are taking certain benefit, if you are acquiring certain benefit, if you are accruing certain benefit, then you have to take the liabilities which are interwoven with it. Are you able to get it what I'm saying? Now we are moving to the other topic. Okay, so yesterday in the last class we have discussed something about a person's entitled to ask for partition. So that is no such big issue. We have to arrange the series of events which happened in Hindu law. Pre-partition, post-partition, these are the things which should be fresh in our minds. What are the technicalities which are involved and how this particular concept has evolved. After the Amendment Act of 2005, a daughter would be a co-partner and she would have all rights to ask for partition. After 2005 amendment, as a general rule, what was the practice? That both Mitakshara and Dayabhaga school, in those schools, every co-partner has a right to partition. And every co-partner is entitled to a share on partition. That is a rule in Mitakshara and Dayabhaga. Apart from co-partner, no other person used to have a right to ask for a partition. No female except the daughter has a right to partition. But if a partition takes place, there are certain females who are entitled to a share. These females are father's wife, mother, grandmother, and so on. Under the Hindu Women Right to Property Act 1937, a Mitakshara co-partner's widow took the same interest which her husband had at the time of his death. So she was given the right to partition. Under the Hindu Succession Act, when a co-partner's interest devolves by succession by virtue of application of Section 6, widow, daughter, mother, predeceased son's daughter, and widow, predeceased son of a predeceased son's widow, and daughter are predeceased daughter are the females who are entitled to share. This we have already discussed in length in many of our lectures. We have seen that what is the picture in relation to the position of the female. So an alienee co-partner's interest, whichever such an alienation is valid, also has a right to ask for a partition. However, when we talk about the widow under the Hindu Succession Act, a Hindu Women Right to Property Act, or female under Section 6 of the Hindu Succession Act 1956, or the alienees of the co-partners undivided interest may file a suit for partition, and such a partition is entirely different than that made at the instance of a co-partner. In such a partition, severance of status does not take place. What happens is this, that the female or the alienee gets her or his share ascertained, and the property falling to her or his share is separated. So this particular instance is there, while the family continues to be a joint family in the rest of the property as before. The general rule that every co-partner has a right to partition is subject to certain exceptions. That okay, every co-partner is having a right to partition, as we have seen that. Okay, there are certain exceptions, and the particular exceptions which we can say that the very first is that an unqualified co-partner has no right to partition. Also, in Bombay school, sons cannot ask for partition against their father if the father is joined with his own father. If father is joined with his own father, that means with the grandfather or collateral. So another qualification to the general rule recognized under the Mitakshara jurisdiction is that the father's right to partition is superior. Under the Mitakshara, we can say, to the right of all others in partition. The father cannot only effect a partition between himself and sons, but he can also impose what we can say a partition on his sons interstates. This does not apply under Daya Bhaga school, because the Daya Bhaga school, in Daya Bhaga school, the father is termed or deemed as an absolute owner of all the properties, and the question of partition during his lifetime does not arise. So the Daya Bhaga school is having a sort of a premises on which the Daya Bhaga school is standing, that the father is the ultimate owner and he is the absolute owner. Therefore, no partition can take place during his lifetime. If he likes, if he wills, he may distribute his property among his sons. So this is what we have to realize. What is the background? I'm not saying that it is a historical background, but in brief, what is the basic difference between both the schools of between Mitakshara and Daya Bhaga? Because these are the basic differences which create different equations. You will to get. Okay. And therefore, we should know what is going on. So, when we talk about the term father, the father, by virtue of his rights, he can make partition not only among himself. So, it means that a father, by virtue, has a right as a patria potesta. This is a Roman term which means the right of the father, the legal right of the father on his sons. Okay. So, a father, by virtue of his right as a patria potesta, can make partition not only among himself and the sons, but also among the sons intestate. So this is what we have already discussed before I started to give you a brief introduction about the persons entitled to ask for a partition. A father must allot equal shares to all of his sons. It is an absolute right of the father to make partition, and the consent of the sons is immaterial. The partition is binding on the sons unless it is avoided or recited expressively. Okay, so these are the few, we can say, important elements when we talk about the term of the father. The father has not a merely right to partition between himself and his sons, but he has also the power to effect a partition among the sons. This seems to be the last survival of father's absolute powers. The Matakshara school of law expressly confers this power on the father in respect of not only father's separate property. So this particular concept has been discussed in the case of Apurva versus CIT. In this case, it has been discussed that the Matakshara school confers this power on the father in respect of not only father's separate property. Every person has the power to distribute or give away one's own property as one wishes to do, but also in respect of joint family property. Okay, so he's having the same power not for his own property but also for the joint family property. In the second case, which is known as Alluri versus Danto Luri. Okay, and also in this particular Apurva versus CID, in both the cases, it has been discussed that no other person has this power in to exercise particular power, this power, and while exercising this power, we can say the consent or dissent of sons is immaterial. The father can impose even it is necessary. The father can even impose a partition, partial or total. Partial, what we will be seeing it, and total between his minor sons and himself. Partial means half or whatever. So the father can impose even a partial partition or a total partition between his minor sons and himself. So this was what discussed in these two cases. Now, when we further talk about the case of Venkat Subramanya versus Ishwara, in this case, but particularly, it was held that, however, it is necessary that the father must act bona fide. He should not be unfair to anyone. Okay, that is talking about good faith. Then, in the case of Giriraj